All right, good morning, folks. This is the Colorado Energy and Carbon Management Commission, July 8th, Wednesday, weekly meeting, and we will start with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have five commissioners present.
Good morning, everybody. Good to see folks. Um, we have a slight agenda today. No OGGPs, but a few other things of importance. Let's start with commissioner comments. Anyone have comments? Commissioner Oath.
Thanks, Mr. Chair. Good morning, everybody. I have just a couple of things that I wanted to share. The first is that a couple of weeks ago at our, I think it was June 24th meeting, we released the report summarizing the discussions of the Public Health Studies panel. And we talked about a couple of next steps. One of those next steps that we discussed was having our staff work on a format to collect some comments and thoughts from stakeholders. So I wanted to share that they have been working on that we have a feedback document that will be posted on our website this morning, and we'll leave that open for 30 days and would hope that many folks, if after they've had a chance to look at the report or watch the presentation from our meeting a couple of weeks ago, if they have thoughts and things that they'd like us to be thinking about and considering, that they share that through that venue. So that was the first item. Excuse me. The second is happy to announce that we have our first ever community impact tour happening in the Western Slope in August. As you commissioners know, so this is more for folks who are listening. We hope this is first of many opportunities for us as commissioners to attend those community tours and learn alongside all of the Coloradans. And so I want to, thank certainly the community members who requested these tours in their letter that they sent last year, as well as Jessica Chavez, our environmental justice community liaison, who has been leading the coordination effort on our end. So these tours are going to replace our commission meeting in the first week of August, and we're hoping to see many folks there. By the end of this week, we will post on our website the locations and dates for each of the kind of specific community meeting, or on our community meetings tab on our website, excuse me. And so if you've got questions or want more information, Jessica Chavez is the key person to reach out to for more information. And that's all I've got. Thanks.
Thanks so much. Appreciate both of those comments and information. Other commissioner comments? Commissioner Cross?
Thank you, Mr. Chair. I just want to provide a quick update that we had another meeting of our 2B working group that came out of the petition for rulemaking last fall. We are coming close to a conclusion of that. We've gone over a lot of information over the 6 meetings that we've had thus far. And in our next meeting, we will be discussing summaries and potential recommendations to the commission. And so I will work with Hearings Manager Thomas to set up a time for us to present probably early this fall based on the conclusion of those meetings.
Excellent. Thanks for the additional good work there. Others with thoughts or comments? I would just want to welcome our new community relations manager, Megan Adamczyk. She will oversee ECMC's community relations strategy, environmental justice work, local government relations, and complaints program. She has, in our mind, the ideal blend of community relations and technical skills to lead the work of the community relations unit. She began her career as an environmental scientist and has worked with ECMC since 2015. She joined us in the community relations manager work group here recently. Previously, she served as the complaint specialist, which was difficult. She ran the ECMC's complaints program, coordinating with technical staff to resolve complaints from the public. As that position grew into her current role as community relations manager, She took on the management of the ECMC's local government designee work, as well as a variety of community tasks such as creating outreach media, planning community outreach events and stakeholder meetings. We welcome her as our community relations manager and look forward to her continued leadership as we continue to build and refine ECMC's community engagement work. Thank you. We welcome you. Thanks for coming on board in this new position. Others with comments? We move to consent agenda. Does anyone have questions on consent? Seeing none, I move to approve consent. Do we have a second?
Second.
All those in favor signify by saying aye. Aye.
Aye.
All right. Consent is approved. We move to a discussion about the practicability assessment guidance document. To sort of tee this off, I worked with staff as well as stakeholders to work on trying to create additional guidance around what the commission thinks is appropriate for the practicability assessment protocol. We have sent around a revised guidance document that has input from staff, input from me and the AGs, and input from some of our stakeholders. At this point, what we're looking to do is provide input or commentary from commissioners. AAG Boudreaux, if you want to visualize, I'll let you help me with this. Ultimately, the commission is not going to adopt this as its own guidance because that would look a little too close to being a rulemaking, but it'll be a guidance document from staff. However, the commission can endorse the document, provide guidance to it. Today's opportunity is for guidance from commissioners, and then it goes back to staff, and then staff would finalize and publish the guidance document. AG Boudreaux, you've been really familiar with this work product that we've done. Do you want to add anything to sort of tee up today's discussion?
No, I think that's a great summary, Mr. Chair. That's the idea here is to get input from commissioners on their thoughts of the current version and then guidance to staff on how to finalize it. But ultimately, it will be guidance from staff, and the commission will not vote on it.
All right, commissioners, questions, comments, deliberative thoughts, otherwise, who wants to talk about it? Commissioner Messner and then Commissioner Ackerman.
So, but before I talk about some of my thoughts, I wonder if AG Boudreaux could provide a little perspective on, or whoever would be appropriate, on what is a guidance document, how it is to be utilized by staff, by operators, and by the commission.
Yes, so typically guidance documents are issued by staff, often to operators, and the general idea is to provide some direction, typically to applicants, on how staff interprets a certain rule or what the expectations are when a rule doesn't address sort of minute details of exactly how a particular part of an application is meant to work. And that's kind of where this practicability assessment guidance is meant to go, is to help operators understand what sort of the commission and staff's expectations are, what it is you would like addressed in the practicability assessments, with the idea being the practicability assessments that the commission has seen so far have kind of varied in terms of level of detail, amount of sort of documentation or let's say evidence presented to support the assertions made in the practicability assessments. And, considering the fact that I think a number of commissioners have expressed concern with the way some of these practicability assessments have come in, the idea is to help operators sort of flesh out their practicability assessments in a way that allows you all to make a informed assessment about whether or not a particular ESP is practicable or not. and also to help operators sort of reduce their risk of denial or stay due to what the commission might view as an insufficient practicability assessment. So the overarching idea here is to help operators come up with a thoroughly drafted practicability assessment that will help you all assess whether or not a particular ESP is or is not practicable for a particular OGDP, and also to help operators reduce their risk of stay or denial.
And AG Boudreaux, can you speak a little bit to guidance versus rule? Like, this isn't altering the rule. The rule is what it is. And this is just helpful information, voluntary to help operators seek compliance with the rule. Like, I think that's an important component to this.
That's correct, Mr. Chair. So the guidance is not rules. Ultimately, what's in the guidance, we're presenting it as, and it is, recommendations to operators rather than requirements. That's why the commission is not voting on it. So ultimately, it's for the operators to decide what practicability assessment they want to move forward with to hearing. And for operators, it's, their risk if the commission expects, let's say, for example, certain evidence to support that maybe grid power is not available for permanent production equipment, um, ultimately it's for the operator to decide what practicability assessment they want to move forward with, just like it's ultimately for them to decide what, say, Form 2A or overarching OGDP they want to move forward with. And it's part of their sort of risk tolerance calculation moving forward of what they think is sufficient, what they think the commission might find sufficient to reduce their risk of stay or denial. But ultimately, these are not requirements. These are recommendations to operators. And one of the reasons why the commission is taking this up rather than staff just doing it unilaterally is because commissioners have expressed in the past that some practicability assessments have seemed, sort of light on details and evidence supporting the assertions made in them. And so the idea here is to provide operators with a little more detail about what it is you all would like to see, and also, of course, what staff would like to see, and what to help operators kind of present a more um, so let's say thorough and well-documented practicability assessment.
And commissioners, just to put a fine tooth on it, we don't have to do this. We can leave the rule as is and let operators interpret the application of the rule to OGDPs as they will. That's fine. I worked with staff to try to bring into this document what I have seen in terms of what commissioners have questions about in terms of application of practicability assessment, because I had seen a differential between what was being presented versus what commissioners were asking. And so that's why we took up the idea and the opportunity. But it is literally up to us to determine whether to go there, and if so, how to go there, and if so, what the guidance needs to look like, and then send it back to staff for them to ultimately make some determinations. So hopefully this is a root cause that makes some sense. It can be helpful to everyone, but it doesn't have to be. It's literally up to us, and the rule will remain the rule. Commissioner Messner, with all that, do you have thoughts, comments, questions?
Well, no, that's helpful. I mean, I'm really just trying to set the stage because I think oftentimes there's confusion between rules and guidance, and we've heard at different times we followed staff's guidance. At the same time, up until this point, staff guidance has been just that. It's what staff was expecting, as far as what they were comfortable with in interpreting a particular rule. This one's a little different in the way that we're approaching it, which I really appreciate. I think the key there, at least for me, from what I heard, is that it's to be utilized by staff in reviewing and determining whether or not the applicant has met the practicability assessment bar. And then independently, as commissioners, we make that um, determination as well. And this is really setting the stage for what information would be most helpful in allowing both staff and the commission to make a determination of whether or not they've met the burden of proof associated with the practicability assessment. And so I think that's helpful. I'm going to hold my thoughts after that. I just wanted to get a little bit of like overarching perspective on guidance versus rules and the roles of staff in utilizing guidance and the roles of the commission in utilizing guidance. And so I'll defer to Commissioner Ackerman if he's got thoughts.
Commissioner Ackerman.
Thanks, Mr. Chair. As one commissioner, think this document is very well done. I think it's necessary. The reason I think it's necessary is because I think by and large, as you alluded to, the practicability assessments that we've received so far differ significantly from what I expected and at least what I personally intended during the passage of the cumulative impact rules. And the way that they differ really is in thoroughness. And I think this document goes a long way to helping set forth the expectations of what we're looking for with regard to thoroughness. And so I had one potential addition and then just a couple of wrap-up comments. And I wanted to kind of raise the addition here of, if you look on page 8, we start to put forth a couple of lists, and the lists are some examples of documentation. And we're careful to say, listen, this is what the type of thing we're looking for. This is not a comprehensive list. It's not limited to this. But I do think one important thing always comes up here, at least from my perspective, and that's future plan development in the vicinity or lack thereof. And so, I would propose that we add that as a number 8 on the top of page 9 to help people kind of focus on, hey, we want to hear if you've got future plans in this area. The cumulative impacts are diluted by the number of developments that are going to be proposed and built in the future. And I do think that's also applicable to the other 3 lists below it as well. So something that's on my mind. I don't think it's imperative that we add it because we do say including but not limited to, but I like the opportunity for them to see it on paper and focus on being able to report that proactively rather than in response to what tends to be my consistent question there. And I'll just finish with my comments there, Mr. Chair, and then happy to discuss that more if we want to. If not, then I'm okay as well. And I think, to me, I wanted to kind of set forth the intent of my thoughts on the practicability assessment in this discussion. And to me, the key issue here is the cumulative impacts rules are intended to reduce cumulative impacts. They're not intended to be an off-ramp. And on the bottom of page 4, we put forth the real world issue that operators seem to be treating the practicability assessment as another piece of paper, an off-ramp of first resort. And to me, my mindset is generally the answer to that off-ramp is no, unless it's fully set forth and is actually practicable rather than just kind of a rote and menial description of what's happening. So I think, to me, the spirit of the requirement of the practicability assessment is made a lot more clear with this document. And to me, in one statement, it's be expositive on all fronts. We can't determine practicability with a very menial description of one or more elements of a practicability assessment. So the intent here is for operators to be expositive on all fronts and help us understand why it really is the best thing to move past the rule that we set as an important cumulative impacts rule. So those are my thoughts, Mr. Chair. Thanks.
Thank you, Commissioner Ackerman. And if AG Boudreau, I hope you're taking some notes or some of your staff are taking notes to help capture this. Frankly, I think this discussion should be captured and framed as a statement of basis and purpose around the guidelines because I think that's what's really helpful. And so I'm hoping that the 69 participants that are listening in are some of the operators and some of the operators' attorneys who can take all this to heart because I think these are really good thoughts and comments. Commissioner Oath, you wanted to speak up. Please go ahead.
Yeah, thanks, Mr. Chair. I too, in response to your comment that we don't have to do this, I'm definitely in the camp that I think that we should do this. I think this is really beneficial and will hopefully help us all avoid kind of some frustration that we've had at times of in going through this process. So I think this is a really positive and beneficial step and document. In terms of specific comments, I just wanted to note, Mr. Chair, I think when you first introduced this idea a couple of weeks ago and in the first draft, there was an element in there about the 5 criteria and are they in ranked order and whatnot, and I see that has, it's my understanding, I think that's been removed, and I support that removal of that concept. I think for me anyways, I had not viewed those criteria as being in ranked order, and I think kind of they're all important to me to help balance and understand the full situation of what the trade-offs are of what we'd be looking at to evaluate feasibility. So I support that change. I just wanted to make that clear. And I support the suggested additions from Commissioner Ackerman. I think that makes sense. Also, I think my remaining 2 comments that may or may not warrant additional discussion depending on others' thoughts is one, in a way, it kind of goes back to what we talked about at the beginning with Commissioner Messner's question to AAG Boudreaux and kind of what is the role of the document and how is it to be utilized by operators and the staff and the commission. And I think in particular, it's that middle component of the staff and what's our staff role in reviewing the practicability assessments. I think in the rules we have noted that that the staff would include a discussion of the practicability assessment in the director's recommendation, and to me that's really important. I would like to see an analysis, by our staff of the PA, and certainly ultimately we need to make our determination of whether or not we think the practicability assessment meets the requirements of the rules. But I think that it would be very beneficial also for our staff to take a hard look at it, and particularly with the guidance now that would be in this document. I think that provides a lot of guidance, I guess, for lack of a better word, for our staff to really make sure that they feel like an operator has included the information that the commission is likely going to need in order to make a determination and an evaluation, and to do some assessment in terms of their level of expertise as well. So that's my opinion. Would love to hear others' thoughts on that. And then my last is maybe a bit of a question. One of the criteria is DD, and now I don't have the exact language in front of me, but it's around, it's asking the operator when submitting the practicability assessment to discuss, here it is, the non-applicability of any enhanced systems and practices in Rule 316 to the respective oil and gas location. And I've always kind of puzzled over that as I've reviewed the assessments that we've received so far. And thinking to myself, well, if they must apply, or else we wouldn't be receiving a practicability assessment, and so I have been puzzled by that, and it sort of came out through the guidance that we don't discuss what we'd be looking for in that item either. So I'm curious if anyone can shed any light and reminder of what our thinking was there, and I think it's important because. At times we have heard comments from operators, that, well, anyways, I'll just leave it at that. I just am curious what we meant by that. And so that's it. Thanks.
AG Bedreau, do you want to tackle that thought?
I wish I could, Mr. Chair, but I'm also unclear what DD is referring to. I view it similarly to Commissioner Oath. If you're submitting a practicability assessment for a particular ESP, it would, at least in my mind, mean that that ESP applies to your OGDP. And so I'm unclear what DD is meant to refer to. I wish I had an answer for you, but I don't.
All right, well, let's table that and see if we have further questions, comments, thoughts from commissioners. Commissioner Cross.
Thank you, Mr. Chair, and thank you to my fellow commissioners for leading off on this. I'll be fairly brief. I also appreciate the hard work done on this document, and I'm in agreement with it. I think I'll kind of talk big picture for a minute. I think ultimately, and I've said this in prior hearings when it's come up about the practicability assessment, I think it's always important to provide as much information as possible. Kind of let's harken back to our school days and the need to show your work. And I think that's really the key thing to me. As a practicing attorney, I try to make sure I had all the information I potentially could before making any kind of argument. And I think that helps shape the argument. And so I think my biggest thing is making sure that operators understand that they need to provide as much information as they possibly can. And I think the examples provided in this guidance do a great job of that, the kind of things we're looking for, who they spoke with, when they spoke with them, what kind of powers needed, what kind of alternatives there were, what kind of timelines there would be, et cetera. I think all that is very important. And I know it's come up in some of our prior hearings as well, that sometimes the information that's being asked for may be confidential business information. And I also encourage operators that if you understand that you have confidential business information, let's get out ahead of it. Let's set up an executive session with the commission to provide that confidential business information ahead of time. And so that way we're prepared for it, and we as commissioners can review all the necessary information. I think ultimately there is no objective right-line rule to reasonableness, to practicability. And so therefore, I'm glad that this is being done in a guidance document. I'm glad we're not trying to go back and change rules or anything else like that. Because I think that there's not they provided this, therefore, or this argument was made, therefore it is practicable, or therefore it is not practicable. I think it's always going to be done on a case-by-case situation. That's inherent in the process. And so I just encourage operators to use this guidance and to provide as much information as they possibly can, because the more information provided is going to be better.
Thanks, Commissioner Cross. Again, I would point out that the purpose of the document is to provide an inexhaustive and volitional list of thoughts around how to be more reactive to the practicability assessment. We tried to frame that in the guidance document itself several times. And so if something's not listed, that doesn't mean it doesn't need to make its way into a practicability assessment. It's just that these were the ideas around what things could be helpful to the commission in undertaking a practicability assessment. Commissioner Messner.
Thanks, and I appreciate my fellow commissioners' thoughts on this, and generally would agree with their thoughts. I think this is a necessary document, and so as I was reading through it, I think, and it's come up in these discussions, there's a reasonableness and a practicability evaluation that gets done in the practicability assessment. What's missing in the document, and I think it's appropriate that is missing, is the term necessary, which often coupled with necessary and reasonable, because I think the legislature has determined that these ESPs are necessary, right? So they are required, they are necessary. And so the applicability then is, whether it's reasonable and or practicable to be able to apply some of these things. And, I think the reasonableness, is an important consideration as we look at this from a performance-based land use standpoint. I think performance-based land use, as we look at these practicability assessments and apply our judgment, um, creates flexibility for operators to be able to make different arguments or utilize different technologies or different techniques to be able to show that they are still able to be protective if it's not directly applying the ESPs that are being proposed. But I think ultimately the burden does lie on the operator, both with the practicability assessment and every other element of an OGDP. And so I think it was well written. I think it's clear to me as far as some of the things that need to be thought about. I think Commissioner Cross is right. I think about it as a trust but verify type of approach where it's not that I don't believe what the operators are saying in a practicability assessment or other arguments that they may be making before us, but there still has to be evidence that backs up those statements so that not only are we hearing what they're having to say, but there's evidence that indicates that this is in fact true. And so that's the same type of information that I would need in a practicability assessment, and I think that's captured in the guidance. I do want to talk a little bit, I think, about what Commissioner Ackerman talked about, which is, looking a little more holistically at these ESPs and how they get applied. Understanding, one of the advantages of the comprehensive area plan is you have a really good picture of what's happening comprehensively and cumulatively in a particular area and understand what kind of infrastructure is or may need to be developed in order to be able to minimize and mitigate impacts and cumulative impacts. And especially when we start talking about oil pipeline takeaway, produced water pipeline takeaway, storage tanks, it's easy to make calculations that if we take, one pipeline from this one OGDP and take it to whatever the nearest receptor is that it needs to go to, that could be problematically impactful. But at the same time, if it's reasonably known that there is going to be additional development that's happening in the area, and we're looking at the potential impacts associated with truck traffic and other impacts, whether those are emissions impacts, that it may, in the end, be less impactful long-term to have the short-term impacts of the development of that pipeline versus the long-term impacts of multiple locations that have chosen to utilize or not utilize pipeline takeaway if it's reasonably foreseeable that there's going to be additional development in this area. And so just indicating that, the nearest receptor for a produced water disposal well is 20 miles away. And so therefore gaining the necessary right-of-ways and installing that infrastructure in order to be able to move that produced water is impactful in relation to this one OGDP. If it's reasonable that there's going to be multiple OGDPs in this particular area, I think that calculation changes. And so for me, at least looking at it, it's important to capture holistically as reasonably possible what some of the anticipated development may be in the area before just indicating that, these 20 miles of pipeline that are going to need to be developed, may have to go through, a couple of, wetland areas, or it may need certain amount of right-of-ways, and, the emissions associated with developing this pipeline are X. And so therefore on this one OGDP, the truck traffic is going to be less impactful without understanding that the potential for tying into this infrastructure of multiple OGDPs may actually change that calculation. So Um, uh, so I think I just wanted to make some clarity, at least my perspective on how I'm looking at that in particular, in as we're looking at infrastructure, and there's a lot of discussion in the guidance document around infrastructure and the practicability associated with that. And then I think the only other piece that I would add is, I agree with Commissioner Oath that the practicability assessment and the guidance that's being developed here is to aid, both the commissioners in our review of an application, the operator in their development of the application, but also staff in reviewing that application and the submittals associated with the application and making a determination of whether or not they feel like that meets the rules or not. And the practicability assessment and the ESPs are rules that have to be applied. And so a summary or a narrative within a director's recommendation associated with the practicability assessment, I think, is a really important tool, and a necessary part of the director's recommendation, as we're looking at ESPs and practicability. So, but generally, I think the inclusion of what Commissioner Ackerman indicated is, makes sense to me, and so those are my thoughts and perspectives, I guess.
Thank you very much, Commissioner Messner. I really appreciate those thoughts. Um, wanted to get back to Commissioner O's thoughts about DD, which is the non-applicability of any enhanced systems and practices to the respective oil and gas location. And I guess I could like throw out like an example. Um, sometimes a location is only facilities and not wells, and therefore electric drilling would not be inapplicable, would not apply. So that's just like one example. As I'm trying to sort of sort through the idea of that issue. So we just sort of throw that out there. Um, but I also want to, and I'm trying to figure out like a way to, how do we capture this discussion for operators? Because it's a really good discussion. And again, as I pointed out earlier, we generally have a statement of basis and purpose around our rules. I don't know exactly how to capture the discussion so that operators can kind of capture it as well. There's 70 folks listening in. Hopefully they're getting it. But really, we're just trying to be helpful about how to apply our rule in a pragmatic manner. So let's keep the discussion going, and I'll have AAG Bedreau, keep comments and thoughts together. But it sounds like there's general agreement that this is a helpful document. Does anyone disagree with that? All right, seeing no general disagreement, we don't really have to do anything further with the document. We're going to send it back to staff for them to finalize and create guidance that is consistent with the document that we produced. I want to thank our stakeholders for their engagement around the production of the document. That's been helpful. And I would, I don't know if I need to motion it or just sort of suggest that we send this back to staff and let them manipulate it in a manner that is consistent with their thoughts and issue it as guidance from staff. And we, as commissioners, look forward to folks utilizing it in a manner that is reflective of practicability assessments going into the future. AG Bertro, how much did I butcher what we need to do next?
No, I think you got it. No motion necessary, no vote necessary. I think this discussion has been helpful. I just want to clarify The only requested addition to the actual document is Commissioner Ackerman's request at page 8 that we add a new item 8 to the list of evidence, and that is future plan development in the vicinity or lack thereof. Did I miss any other specific requests?
Commissioner Ackerman?
Yeah, thanks, AG Boudreau. That's, I think, the exact language that I proposed, unless you see any problems with it. My suggestion also was to add it to the 3 subsequent lists.
Got it. And then I have notes on the rest of the comments that the commissioners made, so thank you all. But yeah,
In-
Mr. Chair, no vote, no motion. I think staff has their direction.
I think, AG Boudreau, if there's a way to capture the essence of the discussion from the commission around the document without making it a rulemaking, we don't want that to happen. I think that would be helpful. Um, so, and that's a difficult task for you as a lawyer, I get it. But if there's a way to do that, I don't want to just like miss the discussion that was had today. I think it was really fruitful.
I think we can add an introductory paragraph to the top of the document that captures some of this discussion here. And staff has notes on what y'all discussed. So if that would be okay, I think that would work well. I'd rather there not be a separate document that starts to look like an
Yeah,
SP because this is not a rulemaking.
yeah, I get it. Commissioners, are you okay with that? That sort of introductory document, Commissioner Messner?
Yeah, I think introductory document's fine. I mean, I think some of the things that were talked about, I would encourage staff to incorporate into the sections, as they see fit, whether it's talking about um, you know, pipeline infrastructure or storage tanks, or whether it's talking about, more holistic approaches to things, looking bigger picture, which I think, Commissioner Ackerman captured generally in his in what he has suggested in language, but um I think it can be as an introductory piece, or it can be integrated into the document in appropriate places, or Commissioner Oath's part about how staff would utilize the guidance document and so on and so forth, and the director's recommendation. So I don't want to be prescriptive in that, but I don't know as it has to all be like in an introductory paragraph. I think it can be incorporated in different places as appropriate.
Fair enough. And I would also point out to commissioners that, this is a green document, a living document. And as we continue to see practicability assessments, further refinements to make sure that everyone's working on the same page makes a lot of sense. And so let's not like shelve it and like say this is over. Let's publish it, let's consider it, and let's continue forward with our OGDP reviews and be receptive to the concept of potential additions, retractions, etc., from the document as we move forward. Commissioner Cross?
Thank you, Mr. Chair. My one final note would be, obviously there have been applications that have been filed in the interim before this guidance was initially put forward, as well as before our discussion today. And so I think it's important to at least recognize that we'll probably still have some applications that are not using this guidance. But to the extent that's the case, I also encourage operators, as they prepare, even though it may not be in their initial practicability assessment, if there's additional information that they have that's consistent with this guidance, to make sure that they have that prepared for hearings as well, to be able to provide that information.
Yeah, I agree completely. In fact, in some of the discussions that I had with operators around the practicability assessment, there was a acknowledgement that they file the practicability assessment with their original OGDP. They then go and have discussions, for instance, with CDPHE, and they come up with a number of different uh, best management practices, and those may influence their practicability assessment. And so I was cool with the fact that, if you want to like refine it and file something else, go for it. We're all looking to get to the end game of showing how it is that things are compliant with our rules. So I think that makes sense. All right. Any further discussion on practicability assessment guidance documents? All right. I think with that, we'll close that discussion. We're not supposed to have a motion. We've got a lot of suggestions, and we hope to inform staff to work with the operators and with our stakeholders to provide guidance consistent with the discussion that was had today by the commission. All right. Next, amongst other things, commission discussion of joint letter from environmental NGOs requesting discretionary guidance for Rule 307B. To tee this up, I think we heard from staff that they had looked at the letter requesting denial criteria, and they provided us with their perspective. I think at this point, we're supposed to sort of take it up to determine whether we need to do anything more at this point on the request from the ENGOs on the idea that we need to do more than we already have regarding denial criteria. And I mean, I'm happy to start a discussion about it, but I'm really looking forward to discussion from fellow commissioners. We have like 160 some odd rules. I don't know exactly the amount. And if an operator proposes an OGDP that doesn't meet one of those rules, then that de facto, in my mind, is a denial criteria. Like you didn't meet rule X, therefore you can't get approved. And so while I'm conscious of the fact that our rules do not elaborate around how it is that not meeting one of those 160 some odd rules is a denial criteria, it is in fact a denial criteria. And so I, as one commissioner, do not believe we need to elaborate around that point because it's in our rule book already. So I think those are my initial thoughts around this request. And I want to not be dismissive around the idea that the commission does not utilize its rules in a manner to ensure that approved oil and gas locations are not protective. I think our rules are the strictest in the nation. I think our rules are thus the strictest in the world. And I think that we apply them in a manner that ensures that approved oil and gas locations are protective. I think I've said this before. If the Colorado legislature wants us to deny all oil and gas permits, go for it. Tell us that. Legislate that. Then we can do that. But that's not what you've told us. And I know that frustrates some folks that we do not say no to every oil and gas application. I would also note that the majority of oil and gas applications that are applied for since 19181 are far more protective than previously. Oil and gas operators are not asking for permits that are not approvable. They realize the vast change in what we're doing. So with that, I don't know that we need to specifically define denial criteria. I think we already have them. So I guess those are my initial thoughts on this topic. Commissioner Cross?
Thank you, Chair. And I do have some notes that I took down on this for kind of at least my own personal feelings on it. I would note that when Commissioner McGowan was still on the commission, she and I traveled all over the state to go to listening sessions in conjunction with the cumulative impacts rulemaking. And this topic is something that would come up during many of those discussions. And both Commissioner McGowan and I would try and probe and say, what kind of criteria are you looking for? And really, it was just a way, what we heard was constantly, we want to know when you'll say no. And kind of the follow-up question we always had was, don't we already do that? If it's not protective, if it doesn't meet the rules, doesn't that do that? And they're like, but we want to almost have a box checking exercise that says, if this, then no. And Chair, I do agree with you. I think that in my view, if a rule is not met, then it is a denial criteria. I think that it's a little bit more nuanced than that, only because some rules are very objective. Did you file this plan? Does this plan have the necessary components to it? Other rules are much more subjective, and I think that's ultimately where the discretion comes in. And so the claim that there's no clear criteria for when an application must be denied, but within this letter, I disagree. The underlying statute and rules are clear that we must regulate in a manner that's protective of public health, safety, welfare, environment, and wildlife resources. And if the commission determines that the application does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources, or if it fails to meet the NOx or greenhouse gas intensity targets or does not meet the rules, it may deny. And that's straight from Rule 307B2. The authors of the letter said that they're confused as to why the commission could vote to approve the Sunlight Long OGDP despite opposition by thousands of neighbors proximate to the proposed location and clear discretion in Rule 307B2 to do so. The decision turned on the lack of denial criteria. First, I think public opposition does not mandate denial. There will inherently be people that support and oppose applications, and you cannot look at just the most vocal contingent. I think we saw that not just in Sunlight Long, but I think we just saw that the city of Erie just saw that in the decision of whether to sell their mineral rights to SM Energy. They had another hearing there, and a lot of people came forward and said they were afraid to speak up beforehand. And so there's always going to be people on both sides of it. So we can't base our decisions just solely on the fact that people oppose something. As you noted, Chair, our legislative mandate is to regulate. It's not to say no to every oil and gas application. And so we're bound by our legislative mandate, not what public commenters think should ultimately happen. Second, the letter notes the discretion to deny, which is inherently subjective rather than objective. And as the letter analyzes the definition of minimize adverse impacts, the letter states that the commission has the discretion to deny an application that does not avoid adverse impacts. That's true. But the statute and rules go further into significant detail about the ability to regulate pursuant to our statutory authority when adverse impacts cannot be avoided. And to suggest that the inability to minimize and mitigate adverse impacts and simply deny where all impacts cannot be avoided would render the remainder of the statute and our rules superfluous and meaningless. Even the letter recognized that the, quote, citizen proposed alternative did not avoid all adverse impacts. Rather, it minimized them to the extent the community could tolerate them. Nowhere in our rules does it call for minimization to the extent community can tolerate impacts. Rather, the ultimate determination to be made by the commission is whether it believes the proposed application, with any attendant conditions of approval or best management practices, will adhere to the mitigation hierarchy and be protective of public health, safety, welfare, environment, and wildlife resources. I found it intriguing that the letter suggests the commission is unwilling to exercise its discretion to deny an application. Yet applications have been denied, including unanimous denials, when the commission believed that a proposed location did not adequately protect FISWE. And finally, I disagree with the letter's argument that the commission, quote, cherry picks when it can and cannot exercise discretion or make subjective decisions. Every decision we make is ultimately a subjective discretionary decision based on each of our own individual beliefs, backgrounds, and expertise in conjunction with our evaluation of that application. And so while this letter isn't solely about the Sunlight Long application, I do think the discussion of that hearing is implicit in addressing this letter, especially as the letter constantly references that hearing and discussion. Ultimately, I disagree with the description of a tortured rationale for that decision. Ultimately, 3 commissioners determined that the application did meet our rules and included necessary and reasonable best management practices and conditions of approval to protect public health, safety, welfare, environment, and wildlife resources. 2 commissioners expressed a desire to stay the application to gather additional information. They did not include it was not protective or could not be protective. And that commissioners disagree shows that all 5 commissioners did exercise their discretion in evaluating that application pursuant to Rule 307. Ultimately, I agree with you, Chair. I don't think we need discretionary guidance. Rather, I believe the statute and the rules speak for themselves. Every decision the commissioners make will ultimately have a subjective component and therefore must be made in each commissioner's individual discretion. I do not see a need to create guidance about how that discretion is exercised. And more importantly, I don't think we need to, as it says towards the end of the letter, develop standards of review, which in my mind would go far beyond guidance and likely constitute a rulemaking. The statute and our rules already provide the necessary parameters for approval and denial, and the commissioner's job is to exercise their own discretion based on expertise, background, and an individual assessment. So I think ultimately I am in agreement with you, Chair. I don't see any need for any kind of discretionary guidance or any kind of rulemaking for this. I think ultimately that's why we're appointed to these positions is to make those subjective decisions. And I think that there have been disagreements on votes shows that we each are using that discretion, which is ultimately going to be subjective and not objective, not something you can just check the box on.
Thank you, Commissioner Cross. Commissioner Oath?
Thanks, Mr. Chair. I think I am thinking about this maybe a little bit differently. So as I reflect on, I think what this discussion is about, in a way, to me, it's somewhat similar to part of the conversation we just had in the last agenda item, which is, that we have a rule and it's in place, 307B2, that's, says if the commission determines the OGDP, isn't sufficiently protective, then it can be denied. And so the question is, do we need guidance to help further interpret that rule, either for operators, for staff, or for ourselves? And I think in the last case, it made a lot of sense. And, in some cases it does, to be more prescriptive, to provide more information around what we mean by a rule, how we intend to apply a rule, how we interpret a rule. And that can be really beneficial in a lot of cases. And in other cases, I think it can be too prescriptive and go in the other direction of not allowing for enough discretion for the commission to be able to have the ability to make a determination in other cases. And so I guess, so I'm thinking about it that way, about, in this rule, there's a piece of it, certainly, that if an OGDP does not meet a specific rule, the commission may deny the OGDP. But it also is kind of this more general discretionary one, right? That if we determine that it does not provide the necessary and reasonable protections for, it does not minimize adverse impacts to, then we may deny. And to me, that is a more sort of open-ended part of the rule. And personally, I think that being too prescriptive about when that would not be beneficial. I don't feel that I need that type of guidance around how I want to or how I do interpret that part of this rule. I think that I understand the request, and I view it in this way and kind of similar to the guidance that we did just discuss. But I think in this case, that being too prescriptive would take away some of our ability to exercise judgment for cases where maybe an application meets, the individual rules and criteria that we've thought of, but there is some reason that we still feel that OGDP isn't does not provide the necessary and reasonable protections for, or doesn't minimize adverse impacts to, then I want to, have that flexibility and that ability to apply this rule in those types of cases. So, while I think about it very differently, ultimately, I agree with kind of the end result that you, Mr. Chair, and Commissioner Cross have articulated.
So, Commissioner Oath, can I ask a question? Is your deliberative comment pointed to the fact that under Rule 307, we have this additional denial criteria that already exists and that there's not a need to further flesh that out? Or is your comment that that's not enough and we need to do more?
Oh, I'm sorry that I wasn't clear. The former. I think that the rule gives us the ability to exercise discretion and deny based on a determination that there are not reasonable necessary protections for, or that the OGDP does not minimize adverse impacts to. And I think that the rule language itself is sufficient. I think that additional guidance around that would be too prescriptive.
Okay. Just wanted to
Yeah,
hone in because I think that really gets to the gut of the request. And
yeah.
so really appreciate the thoughtful comments there.
Thanks.
Commissioner Messner?
Thanks. I've got a few different thoughts on this. I think when it comes to denial criteria or discretionary guidance, I think the denial criteria argument that we've heard a number of times, and I've heard it, as a county commissioner, I've heard it as a planning commission member, I've heard it in this role. It's a fundamental misunderstanding of land use planning, the concept of a denial criteria, because denial criteria at its core is a determination of whether or not the application meets the rules, regulations, land use plans associated with whatever entity is reviewing an application. And so I think that we have set up ECMC's rules and regulations as a performance-based land use planning process. I think there's clear rules in place. Many of those rules, as is the case with many land use planning processes, are subjective and require, independent critical thinking and application of expertise and experience and perspective in determining whether or not what is being provided by an applicant meets the rules and regulations we're reviewing an application by. And so I think oftentimes people get frustrated around the fact that, in subjective decision making and in application of philosophies like the mitigation hierarchy, which is avoid, minimize, and mitigate. And, those are all clearly laid out in our rules. They're clearly laid out in the statement of basis and purpose. They're a very standard application of land use planning across the country. And I think we do a very good job of, applying our expertise and our knowledge and our perspective in these subjective decisions and making determinations of whether or not an application ultimately meets ECMC's rules and regulations and ultimately the act. And so I don't believe there's any additional guidance that needs to be developed associated with, denial criteria. Where I do think that the letter, has some merit, and it briefly talks about it, in performance-based land use planning and land use planning in general, particularly when we've got a lot of subjective decision making that's happening, the development of our findings as far as determining whether or not an application meets or does not meet um, the rules and regulations, that becomes critical because it needs to be clear to the applicant and to the public on why we believe that an application meets the rules and regulations or does not meet the rules and regulations, and the development of our thoughts on that, our subjectivity. And I'm not saying that we do a bad job, but I think that that is where the crux of this is, so that it is clear uh, from a commission standpoint on how we came to the determination we came to. I also think that becomes probably even more critical in the development of the director's recommendation, which was indicated in um, the letter, that findings have to be developed not just on the objective rules, but the subjective rules in a directive's recommendation as well. So like Commissioner Oath had brought up, and I also supported in the practicability assessment, there has to be, in my opinion, a clear development of findings and rationales on how an application meets the subjective portions of the rules as well as the objective portion of the rules in the director's recommendation, so that there's clarity on how staff came to an independent determination of whether or not an application will have a recommendation of approval, denial, or approval with conditions that comes before us. And then it's our responsibility as commissioners to also come up with clear findings on the rationale and subjectivity that we're applying in determining whether or not to approve, deny, or stay an application or approve with conditions of approval. And so, if there are things that we could work on in response to this letter, I would say that, continuing to refine our process for developing subjectivity and findings, subjectivity determinations and findings inside of directors' recommendations, and then us as commissioners doing what I think we do a good job, but I think just being continually aware of the need to develop findings from each of us in determining how we came to the conclusions we ultimately are coming to in review of the applications. I think can be really helpful and help address, I think, this concern that might have been brought up by these groups. But I think denial criteria conceptually is a misunderstanding of land use planning. And, I don't know if there's any direct action that needs to happen associated with development of any kind of denial criteria or denial guidance. But maybe some additional thought on how we develop our director's recommendations, the applicability of both the objective and subjective rules at the staff level, and then, how we deliberate on applications and developing findings and, clarifying how we came to the conclusions we did as individual commissioners. So those are my thoughts.
Commissioner Ackerman?
Thanks, Mr. Chair. I think same flavor, different color from me. I did want to acknowledge the concern, and it does come up from time to time. Our rules are numerous, they're complex, and I get the desire for kind of a one-stop shop that somebody can point to if their goal is to get an application denied. Unfortunately, I think such a rule would of necessity likely be overly broad and subject to even more interpretation than our precise rules currently are. I, like Commissioner Messner, have seen this issue come up from time to time in previous administrative law positions. And I would reiterate that we do already have denial criteria. I think Commissioner Cross set that forth beautifully. And I just wanted to expand on that point just a little bit here. by making a clear statement that really the negative implication of every single compliance-based rule that we have is that non-compliance is the criteria for denial. And this isn't a concept that we've come up with unilaterally, but it's actually a wide-ranging legal construct that's commonly referred to as the negative implication canon, which specifically sets forth that the explicit expression of one thing implies the exclusion of other unmentioned things. So when a regulation or statute explicitly prohibits or allows a specific set of actions, any similar action left off that list is presumed to be excluded. And so the way we set forth our rules is very clear uh, uh, criteria for compliance, and the negative implication of that is a denial criteria. The logic there is that if we list specific restrictions, the general the general legal rule is that we've assumed to have done so on purpose rather than by accident. And so if there is something in our rules that someone can point to that is missing as some kind of a criteria that should be added or met, that would likely be added as a positive compliance criteria with the negative implication of it being a denial criteria like every other single rule. And really courts use this as a rule, as an excuse me, interpretive guide to really figure out the true intent behind a legal text, which is really the meat of a judicial review. And so even in a judicial review, courts would be looking for something that specifically was not complied with rather than some kind of catch-all denial criteria. And so I think our rules follow the general administrative legal construct that's widely used by other administrative law bodies as well as courts, and fall significantly within the best practice of legal implementation rather than striking off a new road of denial criteria. Because in the event that we do put forth denial criteria, the negative implication canon continues to exist. And it certainly gives way for potential conflict between rules that require specific actions and rules that mandate denial under specific actions. I can't speculate as to what those would be, as I think they would just reiterate that you need to comply with every single rule that we've set forth. I think our path forward really would be so to that point, I think rules specifying denial, I think they would be convoluting rather than clarifying. And I would agree that I don't think a guidance document is necessary. I think that's a commission-focused document. I don't personally believe that we need a commission-focused guidance document. We always do have an option for an outward-focused educational document, as we've kind of alluded to a couple times here today for stakeholders and others, which I think, Commissioner Oath set forth well in her testimony. And my preference, really, as opposed to any kind of a separate guidance or educational document, or certainly, criteria for denial in the rules, in addition to, again, every negative implication of lack of compliance rule that we have, would be to, continue to set forth, or maybe even enhance a little bit, to Commissioner Messner's comment, on a case-by-case basis for commission approvals and denials in legal orders that are issued pursuant to our hearings in which final decisions are made. So I think if there's anywhere that we could kind of expose further our rationale for acceptance or denial of an application, I think the most appropriate vehicle would be the legal order. So those are my thoughts. Thanks.
Thank you, Commissioner Ackerman. Others with thoughts? Hey, AG Boudreau, if you could visualize, just trying to figure out like next steps at this point.
So if I'm reading the room correctly, it sounds like the consensus that the commission is not going to take any action here. And if that's the case, then no motion is necessary.
All right. I move no motion. With that, I think that our deliberative thoughts on this matter are concluded. And let's take a morning break. Let's return at 10:30, and we'll take up the next matter on our agenda at that point in time. All right, it is 10:30, July 8th of 2026. The Energy and Carbon Management Commission is back in session. And next, we are going to hear a presentation from Mike Leonard, the esteemed Mike Leonard, ECMC Quality Assurance, Quality Control, and Safety Unit Manager, and general knowledge of all things for ECMC. Mike, we really appreciate all you bring to us. We look forward to your strategic quality control, quality assurance, fleet drone safety unit overview. The floor is yours, Mr. Leonard.
Thank you, Chair Robbins. And good day, Commissioners. Again, yeah, I'm Mike Leonard, manager of ECMC's Strategic Quality Control, Quality Assurance, Fleet Drone, and Safety Unit. And for time and simplicity, we'll just refer to it as QAQC. QAQC was created to help fill a need in the agency in the auditing business process and agency support. As you can see from the slide, the team encompasses several functions and responsibilities. It's a really complicated set of tasks which face both inward to ECMC and outward to industry and our stakeholders. Today, I'll try and give you an understanding of what we do. The unit's made up of 9 full-time employees, plus help from Sienna Madursky with some of the administrative work, and 1 contract employee who works specifically on the financial assurance audit requirements. So let's start with financial assurance. This is a list. This is a list of an overview of duties performed by our staff. As you can see, we're a very important process to ECMC. This team performs the Herculean tasks of processing and reviewing financial assurance plans, making sure required fees are collected, doing detailed investigations to ensure operators are compliant before releasing their sureties, working with surety companies to claim bonds when operators default, processing operator transfers, and finally, auditing our records to comply with Rule 707. Much of the financial assurance work involves legacy paper documents. It requires manually processing of those documents. We've been working on building tools and reports to streamline and modernize all of that. We plan to utilize those tools until the COGIS modernization project and implement them. Along with the administrative tasks, staff frequently has to review operators' financial assurance plans for compliance. The team works daily, replacing and releasing financial assurance plans and sureties as operators fulfill their responsibilities or as they add and subtract wells or find different surety providers that may have better rates. Operator transfers require a review of both the buying and selling operators' compliance and accuracy of transferred facilities to ensure those facilities and incidents are properly transferred. And frequently, there's conditions of approval placed on transfers that require an operator to update their financial assurance plan. With Option 3 and Option 4 plans, operators are allowed to submit demonstrated costs rather than using ECMC default costs. There's a process whereby staff reviews these plans and then makes recommendation as to acceptance or denial of the plan. The review does have specific milestones which are spelled out in the statement of basis and purpose. I mentioned a little about Rule 707. This is a 2-part rule that puts the responsibility on staff to review every plan every year to ensure they're adequate and to review all surety instruments to verify they're still in place and accessible to ECMC. As you can imagine, with over 200 plans that are changing frequently and over 6,000 surety instruments also changing frequently, this is a tremendous task to accomplish in a manual fashion. Initially, much of this process relied on spreadsheets, emails, shared drives, and honestly, outdated accounting techniques. To that end, we brought in Brent Roberts, a contract employee, using Martinez Irwin funds to help clean this up and streamline the process. Over the last year or so, Brent has reviewed records, checked data, and corrected discrepancies, and identified gaps in documentation and reporting. He's also started improving the audit tools we're building. On the outside, it felt like a time-consuming and seemingly endless process that was trudging along, but we really had to clear the room before we could remodel it, and we still have more work to do. Let's move on to production reporting and conservation levy. This team of two are incredibly busy ensuring that operators report production in a timely and accurate fashion, and that they pay the required levy, which, as you know, is a big part of this agency's budget. Production reporting may seem straightforward, but there are nuances in our rules and process that require more attention than one would think. For instance, in a single well, there may be multiple producing formations. Each formation may require a separate entry into the report. A simple typo can cause that entry or entries to be rejected and thereby delinquent. Multiply that by the number of multi-formational wells, and it's really understandable that errors are found and the work is pretty complex. With the addition of produced water reporting, this process has become even more complicated. We do have some electronic tools to aid us, but all those reports still have to be vetted. In the conservation levy world, operators are required to pay levy on production when they sell their product. For gas, it's pretty straightforward. It's produced and it goes on to sales. Oil's somewhat different. Lower producing wells may take months of production to store enough product to transport. Since levies paid quarterly, monthly production may not line up with levy payment for some time. To add to the complexity, not all operators pay their own levy. For example, some have the transporter pay it for them. And this requires some tedious bookkeeping to ensure the proper payment is made. As you all know, ECMC was audited by the State Auditor's Office as required by the Oil and Gas Act. The auditor had findings and recommendations. To summarize those recommendations, they directed ECMC to address the issues you see on the slide. We've made great strides in working diligently to meet the deadlines as agreed to with the auditor. We plan for an electronic version of all this when the COGIS modernization project is completed. For the levy portion of the audit, there were two recommendations. The levy team is working along with the enforcement unit, working on both of those with the enforcement unit. The recommendations really come from the fact that much of the system is not completely electronic and is manually processed. And again, the modernization of the COGIS system will make both production reporting and conservation levy much more efficient. With the expansion of field units in this agency, we also had to expand our rolling stock. It became apparent that with a large number of vehicles, we needed someone to coordinate that process. This task can be complicated as we must meet the requirements of state fleet. These include mileage requirements, vehicle maintenance and repair, electronic vehicle requirements, procurement and replacement of vehicles, all the while aligning our needs with the available vehicles. ECMC's drone program has officially evolved into Project Elevate. Its mission is to expand the agency's capabilities in aerial documentation, situational awareness, and operational support. The program currently consists of 14 FAA certified drone pilots supported by a fleet of 10 quadcopter airframes and 4 ground-based camera systems. In the last fiscal year, Project Elevate responded to 29 flight requests, generated 168 uploads associated with those, and produced 380 total project uploads. In the safety world, we're working on creating a safety team to keep our staff updated as much as possible to current needs. We're starting to evolve the position of quality assurance professional into a more agency-wide asset. Connor shifted some of his direction to get more into the QA/QC facet. He was able to start doing reviews of ECMC documents, such as the continuity of operations plans, and we'll be picking up more of that work as we go along. And the goal is to have a non-subject matter expert review these documents to assure that they're updated, understandable, and readable by everyone. In And lastly, we have our business process analyst. Alyssa's been busy holding 6 form process and improvement workshops, and all that comes as follow-ups to those workshops. And that's in addition to all the process mapping and improvement work that she's been doing. Both Alyssa and Connor have been working with the Trinan team in the COGIS Modernization Change Management section. And with that, commissioners, we'll field any questions you may have.
Wow. Thank you, Mr. Leonard, for that update. Just as a quick question, on slide 11, you talked about the Elevate program, which was the drone program. What happened before? Like before we had this drone program, how did we check things out or do things, and how much of a change is that for the agency?
So it's a huge change. The drone program actually started in the compliance unit many years ago, probably 2017, 2018, just as an addition to the compliance unit. We saw the evolution of it, and other states have as well. They're starting to use drones in many, many facets. And we found that drones can be used in reclamation. They can be used in, spill review. They can map spills. They can do a lot of different things. But we really never had an organized method to send people out to do flights and to keep the data in one place. So the program was put together. In fact, next week we're going to have a meeting to have a governance committee and a governance document for the program to just make an official program, kind of make it more, I guess, more structured than it has been. It's really been an important program, though. I know we've used it in a lot of different ways.
Excellent. Really appreciate that perspective. Commissioners, Mr. Leonard is available for questions or comments. Commissioner Messner?
Thanks, Mr. Leonard. Appreciate the overview and all the work that you do. I know it's a incredibly diverse department with lots of challenging operations, and so appreciate your oversight of it all. As you look at modernizing different elements of the financial assurance and the verification pieces, is there exploration into the utilization of AI, or how does AI play into some of those modernization pieces? Because I know that in some industries that's being utilized as a pretty effective tool for some of the things similar to this.
Thank you, Commissioner. Yes, I don't think we've actually looked into AI as such. One of the biggest things we're trying to do is just get everything moved into an electronic world. Electronic payments would help a lot. We're working, trying to get all the like the marginal well fees and things like that, all that electronic payments. We're looking at electronic sureties rather than processing paper. As you may or may not know, in our office, we have several filing cabinets full of and fireproof filing cabinets that hold the surety documents. And the processing of that paper is what really slows the whole thing down. The banking industry and honestly, the insurance industry has went to electronic sureties, and we're looking at doing some of that to help streamline it and do all that. Electronic documents can be lost, but it's easy. It's really a lot easier to lose paper documents, or misplace them or misfile them or things like that. That's one of the biggest things we're looking at is that electronic document. Having our system talk to the documents as they come in, basically, gleaning information out of those documents so that we can put it into reports and things like that to track payments and to track. So, for instance, in some of the financial assurance plans, operators are allowed to make payments over time to track those payments and see exactly where they are, if that helps. But no, we haven't that I know of, unless the IAT team is working on anything with AI. We haven't specifically in this unit been working with AI.
Yeah, thanks. Seems important to get it digitalized before I think you can even apply it. So one step at a time, right? So thank you.
Yes, sir. Sir.
Others with questions for Mr. Leonard? Mike, we thoroughly appreciate the presentation and the work that you're doing and your continued presence at ECMC. It's remarkable and really helpful. So thank you for all you're doing.
Thank you, Chair Robbins. Thank you, Commissioners.
All right, Commissioners, we've got one more docket, docket 260200031, a variance request from Starlight Energy Corporation. And I believe we're first going to hear from Starlight Energy. So if we could bring that person to the panel, that would be great. Mr. Davenport, do you want to swear in the witness, or is that necessary?
Yes, let's go ahead and do that. Mr. Bentley, my name is Assistant Attorney General Kyle Davenport. As is the commission's practice, I'm going to swear you in before you give information to the commission and testimony. And so what I'm going to ask you to do is raise your hand and then state your name and say that you swear to tell the truth. Please do that now.
Name Brian Bentley. I swear to tell the truth. Is there any other?
Thank you. That's it, sir.
All right, Mr. Bentley, you are recognized. You've got a few minutes here to present your case. Go ahead.
Well, I'll be fairly brief. I assume everybody can hear me and have had a chance to look at the application that we submitted. I'd like to, at the outset, thank Jenna Jacobs and Autumn Treesh for all the time they gave me. This is the first one of these I've ever done. And did I lose you? Oh, okay.
Nope, you're here.
And we're asking, basically, we have one well. Starlight Energy has one well, it's throw number one in Morgan County. It's in TA status, drilled 5,000 feet into the D sand. At the moment, it meets all ECMC inspection requirements, and it is never produced. We plan to complete that well, put it on production this year. And the issue that's come up that we've asked for an application for is a deferral, not a forgiveness, but a deferral of the $5 million insurance requirement. We've gotten bids for that, and it'll cost us $15,000 a year in premiums for a $5 million policy. And what we're hoping to do is to spend the first of that $5 million, if that for $15,000, as part of our capital cost of completing the well. When I say completing, hooking it up and making it capable of production. That in a nutshell is what we're asking for. I had a presentation that basically took us marching through the application, but in the interest of the commission's time, I thought I'd cut to the chase and just indicate what we're trying to do. We're not asking for any kind of forgiveness of the insurance requirement, although quite honestly, $5 million might be a little high at this stage, but that's what it is. So we were asking for a deferral until we start work on the well, certainly before we put it on production, at which point we'll pay the premium and put the $5 million policy on the straw number one, which again is the only well we have. And $15,000 a year is a stretch if we're not cash flowing the well. When we are, it's just an operating cost. So that in a nutshell is what I was asking for the ECMC's accommodation on. And I I can give you more information as the commission wants, but I think that the essence of what I'm asking for is simply a deferral of the insurance requirement, the $5 million insurance requirement, until we start working on the well itself. And at that point in time, the first payment will be a capital cost and then an operating cost from that point on. Now, I can take you all through the details, but I figure that I'm just looking to use your time efficiently, and that's the essence of what I'm requesting. Not knowing what else you may be looking for input.
All right, thank you very much. Commissioners, Mr. Bentley is available for questions regarding his variance request. Commissioner Cross.
Incidentally, I assume you've seen this, not to interrupt, but I assume you've seen the application. So
Yes, it was in our portfolio when we've all reviewed the application, as well as the director's recommendation on the application and other peripheral documents. So we've seen all that. Thank you.
Okay. So that's in
Commissioner Cross.
essence. I'm sorry.
Thank you, Mr. Bentley. And to confirm, you don't have general liability insurance on the well now, correct?
No, I do not. And again, just to emphasize, we're not challenging it. We're just asking for a deferral until we're doing something out there that might create an insurable risk.
So you do want to instead of paying for the premium, you want to start operating the well and then use the proceeds so you can then start paying for the premium.
Oh, no. The first payment we make, the first $15,000 we've been quoted, that'll just be part of our capital costs right at the outset. And we'll put that, we plan to put that policy in place and satisfy the commission's requirements regarding that insurance policy.
That
and then we'll start working.
Would only be after production starts on the well.
In fact, not only production, but work on the well to bring it to a producing status.
So I think that's ultimately my big picture question here is you don't have insurance on the well now.
No.
You want to start working on the well to get it into a producing state and then start making the payments on it. It being one of the capital
We'll
costs.
make the first payment, the first $15,000 to put a year's insurance on the well before we do anything that might create a liability beyond what we may already have sitting out there.
You don't think there's any potential liability at the site absent production?
Absent working on the well, we don't think that certainly absent production, but until we start working on the well, laying pipe, hooking up treaters and tanks and so on, we don't perceive that there is. There's always a theoretical exposure.
Okay.
That well's been there for a long time and has not. It's up to date with respect to all of the commission inspections. And we don't believe until we start working on it that there'll be any incremental exposure.
And with inspections, but not up to date with financial assurance either, correct?
Not up to date on financial insurance, but up to date mechanical inspections,
Okay.
which we tend to focus on as more of a liability question for obvious reasons.
Okay. Those are my questions. Thank you.
Further questions of Mr. Bentley? Commissioner Oath?
Thanks, Mr. Bentley. So I just want to maybe expand a little bit on Commissioner Cross's questions. So first, you said in your comments earlier that the well has never produced. Is that?
It has never produced, no.
It has never produced. Okay. And then can you describe from your perspective when the financial assurance plan and requirements were submitted and the non-compliance part of that and how that fits in from your perspective?
Well, there's two elements that I'm aware of on non-compliance. One is the insurance issue, and with the cost of writing a policy, we already have two quotes from a broker in Fort Morgan. One of them was attached to the application for illustration. And the other is bringing the what I would have called the plugging bond up to where it's supposed to be. It's at $22,000 now for that one well. which is the only well we have, and it needs to be brought to 32,000. And at a rate of something $3,000 a year. It kind of gets out of trying to answer your question. I've offered to pay $1,000 a month for 10 months and bring it up to 32,000 and be done with it. So we do have a plugging bond. And one of the questions that I had, and it gets away from the subject that we're talking about today, is how did that $22,000 that's already on deposit as a restricted bond factor against the 32,000? I've had that question answered now. And on that issue, the outstanding issue is to bring the 22,000 up to 32,000, and we're covered. So those are the two that I'm aware of that are financial assurance issues. I focused primarily on this. Like I sent a note to the ECMC a couple of weeks ago, offering to pay $1,000 a month for 10 months and bring it up to 30,000. I haven't heard an answer on that one, but I've been focusing on this particular hearing, and so I haven't followed back and tried to chase that one down.
Okay. And then your request is to not post or not obtain the general liability insurance now, but to do so prior to doing any work, I think is
Any
like
work,
what you,
any work
yeah.
at all.
So what is the first action that would be taken at the site? What would be the first piece of, action that
First
constitutes work?
We have a separator. This in the picture you may have seen, standing actually at the well site. We would basically set two tanks, 300-barrel tanks, initially, because we don't know what kind of production that well will produce. So initially, two 300-barrel tanks for water and crude oil, and have a service company, Rival Services in Fort Morgan to be specific, come in and hook up the flow lines and set a gas meter. And at that point, we're ready to produce. We go through the inspections that you folks may have of that. We're planning to use the gas initially to make electricity in a oil and gas qualified generator. And we have plans for that electricity. But to answer your question, the first thing we do is set tanks and have the plumbing, not to be too trite, hooked up.
So prior to any tanks being brought to the site and prior to any grading that may need to be done to accommodate those tanks, that would be the first work.
That would be the first thing.
In your proposal would be to have insurance in place before that.
That's right. Candidly, where I would, and this is kind of irrelevant, I'd suggest 2 million rather than 5 million, but 5 billion is what the rule requires, and that's what we'll do.
Okay. And one of the elements of the variance application is around, undue hardship. And so in trying to think about this sequence, it seemed, I guess, maybe what you're trying to say is it's a hardship to pay a $15,000 premium until there's some revenue around this, but you're also proposing to put it up before there will be any revenue. So I'm trying to understand how it's not affordable now, but would be before any of the tanks come or any grading occurs. Like how, and I guess it's just assurance on our part that you would be able to comply at that point.
Well, it's part of the capital cost, and I'm thinking of bringing the well on production. So it's money we spent first. But so far, and as long as we're not doing anything physically at the well location, I would look at it from my standpoint as I don't perceive a liability. You folks would say, get it done. So we would plan to get it done before we start grading or doing anything out there. That's to me, that's part of the capital cost of well completion.
And so maybe just to understand that, so you're saying you'd obtain a loan and the first expenditure of the loan would be to pay for the liability insurance.
Well, however we produce the cash, we would spend that first cash on putting the insurance in place.
Okay.
In other words, I'm looking at it, and the first payment as one that we have to spend to legally bring that well on capable of production. And we'd spend that money, quite frankly, right up front. Because once we start working on the well, that's when we incrementally create the possibility of a liability.
Okay. Okay, thanks, Mr. Bentley. That's all the questions I think that I have for you. Mr. Chair, I think if it's appropriate and if staff is prepared, I think it would be helpful to hear from them a little bit more about their thoughts that are included in the director's recommendation and how they're thinking about this
Okay.
when we get to the appropriate time.
Yeah, let's exhaust our questions of Mr. Bentley, and let's use that as an opportunity for staff to get ready to speak to us about their perspective. Other questions of Mr. Bentley? All right, seeing no further questions of Mr. Bentley, AG Bedreau, would you, I'm going to take a 5-minute break and give you a chance to get staff prep to come back and talk to us a little bit. Does that work?
Mr. Chair, AG Davenport is covering this variance.
Oh, you're right. Sorry. Kyle, talk to me.
Yes, Mr. Chair. What was the question?
Can I give you?
You're looking for staff?
Yeah, 5 minutes or so to get staff prepped to provide their perspective on the variance.
Sure.
Hearings Manager Thomas, does that work, do you think?
Yes, I'm speaking with staff. We'll have them ready.
All right, let's return at 11:07. All right, welcome back. Docket 260200031. And I believe the commissioners may have questions for staff. Commissioner Oath?
Yes, thanks. And thanks, Mr. Leonard, for being here. Appreciate that. I guess I'll start with a general question and maybe a bit of a compound question first. Would just want to open the floor to give you an opportunity to kind of provide your perspective as it is provided in the director's recommendation about the situation here and the reason for the recommendation for the denial of the variance. And I guess compounded or included in that is a request for you to kind of touch on your response to Mr. Bentley's perspective that there's no about what is the risk here if the variance were to be granted.
Yes, thank you, Commissioner Oath. In several things here. First of all, Starlight has never been compliant with general liability insurance. They've never held general liability insurance in reviewing the records. So that kind of goes back to that paper process too that I mentioned before. So even when the insurance was $1 million, they never held any. This well, they've had this well since 2013. It's a well in the ground. It's an open bore. There is a chance for potential contamination, as we all know. There's a risk. The casing could fail at any time. I realize he says it's past MITs. I didn't look into that. It's past MITs, but it could fail at any time. That's what this insurance is for. Does that help you in any way?
Yeah, thanks.
Others with questions? And Mr. Bentley, I'm going to give you a chance to respond after we're done talking with staff here. All right, Mr. Bentley, any response relative to the questions? You're muted.
Okay, can you hear me?
Yep.
When we were producing oil and gas wells, we always had liability insurance. Our financing entities required that we have adequate oil and gas insurance. But this was back over 10 years ago. I don't think at that time we were required to report our oil and gas insurance coverage, liability coverage, to the COGCC at that time. But when we sold all of all our wells, we and had no more producing wells, in fact, no more wells, period. We let our insurance at that time drop. And I don't think at any time were we ever required to report to the COGCC at that time, what our insurance coverage was. If we had, we would have reported it. But we
All
have
right.
not had any coverage since then.
Thank you. Further questions of Mr. Bentley and or staff? All right, then, Mr. Bentley, thank you for the presentation. Thank you, Mr. Leonard, for your participation. We now will turn this to commissioners for deliberation.
Should I stay attached or?
You don't need to. If we need you, we know how to find you. Thank
Okay.
you.
Thank you.
I think I saw Commissioner Messner first and then Commissioner Ackerman.
Thanks, Mr. Chair. So a couple of kind of overarching thoughts. This well is a liability right now, the way that I look at it. Non-producing wells, temporarily abandoned wells, as Mr. Leonard indicated, are a potential risk. This operator is out of compliance now, has consistently been out of compliance, both with general liability insurance as well as financial assurance, and is essentially in this variance asking to extend their non-compliance in the general insurance liability. There's no clear evidence that this operator can or has interest in complying with ECMC rules, as they're not complying now, and so there's no evidence that would support that they would comply in the future. There's elements in Rule 502E that it has to meet in order to be able to be given a variance. And the first one is if they have made a good faith effort to comply and is unable to comply with Rule 705, general liability insurance, and they have not met that. There's no indication that I see or evidence provided that they can't meet their responsibility currently to have general liability insurance, and no belief that they will have general liability insurance in the future. The requested variance will not violate the basic intent of the act is the second one. I believe that this would violate the basic intent of the act, was to ensure the protection of public health, safety, welfare, the environment, and wildlife resources. 5 million general liability insurance policy is what this commission determined was necessary in order to be protective, and so would violate the act by granting this variance. Not clear to me that there's any undue hardship, and so I believe this variance is not necessary to avoid an undue hardship. It is certainly possible that granting this variance will result in a net adverse impact to public health, safety, welfare, the environment, and wildlife resources, as it's currently out of compliance with ECMC rules, both with general liability insurance that is currently required, as well as the financial assurance. So don't believe that they've met that burden. And so therefore the requested variance doesn't contain any reasonable conditions of approval or other mitigation measures that may avoid, minimize, or mitigate adverse impacts to public health, safety, welfare, the environment, and wildlife resources. So in my opinion, I guess overall, they've not met any of the elements associated with this liability. So I would support the staff's recommendation of denial on this.
Commissioner Ackerman. Thank you, Commissioner Messner.
Thank you, Mr. Chair. I'll truncate a little bit as my thoughts are similar to Commissioner Messner's. And I wanted to thank Mr. Bentley for appearing before us. I recognize that this is a small operator with limited experience with Colorado's rules and think of it as such. So my comments aren't really intended to offend him, but rather to pointedly set forth the need for insurance coverage for all of Colorado's oil and gas wells. And I found myself as I was reviewing this, that often as a commission, we have requests or points of law, policy, or rule that raise an argument or a different point of view, which to me requires significant interpretation and deliberation, sometimes resulting in a pretty difficult decision. But with all due respect to this applicant, this to me isn't one of those instances. This variance to me, as pointed out by Commissioner Messner, doesn't meet, in my opinion, a single criteria for a variance. And I won't reiterate the points in detail that Commissioner Messner made, but what I considered was under a good faith effort to comply. I would agree that the evidence is contrary to that. There's never been a recorded GLI. He's currently delinquent, and there's a current active related notice of alleged violation, which even in the searching for insurance quotes doesn't supersede those issues in a good faith effort to comply in my part. And as far as not violating the basic intent of the act, as pointed out by Mr. Leonard, temporarily abandoned wells can pose significant risks. Methane leaks, other emissions, case failing, subsurface migration, groundwater contamination, other potential impacts of gas migration that result in human and environmental potential impacts, as well as the financial and legal impacts to the operator and to the state should we waive GLA on what is right now an unknown risk. So to me, the actually enumerated in statute basic intent of the act is to protect exactly against the risks that this type of situation imposes. I would agree on the undue hardship. Costs associated with oil and gas development are significant. This isn't a cost that's unique to this operator, nor is it a unique circumstance. It's not a hardship, but rather a well-documented and predictable component of the business. There is potential net adverse impact to FSWE, as Commissioner Messner and I have both stated, as well as I don't see any proposed COAs really to mitigate those. And so in each point of the variance, I see that this is failing. So to me, this isn't a matter, as was presented, of shifting the timing of insurance requirements according to an operation start date. To me, it's a matter of bringing a long delinquent well into compliance, regardless of any future plans, timing or no timing notwithstanding. Thanks.
Thanks, Commissioner Ackerman. Commissioner Cross?
Thank you, Mr. Chair. And I'll be brief because I agree. I think to me, the fact that this is a well that's not been in compliance for a long time is very telling. The notion that an open well bore has no liability simply because it's not producing now, it was a little baffling to me. That's like saying there's no risk of a car accident until there's a car accident. And so I absolutely think that insurance needs to be had on the well. They didn't have the prior insurance on the well, and he's pointing clear back for decades of when maybe there wasn't insurance on the well, but that has not been the rule for COGCC or ECMC for a very long time. And so I have significant problems with that. I also just have a really difficult time trying to understand the cyclical nature of his argument of, I can't really pay for the insurance until I can prove that there's going to be a generation of revenue, but I can't really prove there's going to be a generation of revenue until the work starts. But at the same time, I'm going to still pay for the insurance before the work starts. And so it's none of those kind of line up and none of them kind of work together. But overall, I think my bigger concern is I agree that the variance requirements under Rule 502 are not met, because I don't think that there's an undue hardship. He's not trying to claim that this is going to put him out of business or this can't be done. It's just something expensive when he thinks there's no risk at this point in time. That's not an undue hardship and a reason to not comply with our rules. And so I will also be a no on this variance.
Thank you, Commissioner Cross. Commissioner Oath?
Thanks, Mr. Chair. I too agree completely and really don't have anything further to add. So also support the staff recommendation for denial of this variance.
Further deliberative thoughts from commissioners? Do we have a motion?
I'd move to deny the variance application.
Second.
Motion and a second. Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 5-0. All right. I think that concludes our business of today. Some really good business. The variance is important, but the discussions around the various processes was also important. I want to really thank Mike Leonard for being with us for that. With that, I move to adjourn. Do we have a second?
Like,
All those in favor signify by saying aye.
Aye.
We are adjourned. See you next week. Thanks, guys.